So I'm Richard Taylor, it's the 6th of December 2017 and I'm here at the Guildhall in Cambridge. There's a very interesting planning enforcement matter on Councillors' agenda this afternoon, and that's for an Airbnb where there have been complaints of nuisance. Councillors are considering if they should require planning permission from anyone who wants to rent out their property for less than 90 days. Now I think if they decide that they can do that, that would have huge impact both in Cambridge, reducing the supply of short-term accommodation, which increasingly people need if they're living in houses that are smaller than ideal, when they have family visiting for major life events, for example, or when people want to come and work in a city, as they often do, for short periods of time. And I think the impact might be felt across the country. For example, in regions where there are a lot of holiday homes, for example in Cornwall, currently my understanding is that generally you don't need planning permission to rent out your house to holiday makers. That could change if they follow a decision which is made here today.
And now we come to the two enforcement items, the first of which is number 17, Richmond Road. And we have one speaker, that's the Ward Councillor for the County Council, Claire Richards. So Claire, if you would come to the table, please.
Thank you. Hello there.
And if John Shuttle would not come. Right.
Okay.
So you're handling this, are you?
We'll be here in about 30 seconds, I would imagine.
Ah, good. He's on his way. Well, we'll wait for John Shuttleworth because he is the enforcement.
Just tell some jokes. Tell some jokes all the time, you know.
Oh, tell some jokes. I can't think of any. There he is.
Apologies.
All right, there. Kept us waiting for 15 seconds. So, John, would you gather yourself and we can introduce this item? Please, John, carry on. Thank you.
Good morning, sorry for the delay. Okay. This is 17 Richmond Road in Cambridge, which is in the Castle Conservation Area. This concerns the planning enforcement item today concerning details of the alleged breach of planning control, which is without planning permission, the unauthorised change of use of a C3 dwelling house to a short-term visitor accommodation to duress and premises. This report, which I'm sure you've had time to read, concerns an alleged unauthorised change of use of a domestic dwelling house into a commercial short-term visitor accommodation letting use. The recommendation of the report today is to serve one material change of use enforcement notice directed at remedying harm caused as a result of the breach occurring. And I stand here today to ask for authorisation to serve such a notice in due course. This is Richmond Road, it's precisely 17 Richmond Road. This building, the photograph on the left is the middle one just to the left of the tall tree in the front garden. So that's looking at from one side, and you can see it from the other aspects. So it's a typical dwelling residential area in the conservation area. Now, we received complaints initially from local residents of noise and disturbance as a result of increased comes and goings from the premises during the early and late hours, allegedly as a result of change of use to an Airbnb type property. An investigation was carried out and it was deemed that the premises was being let out on Airbnb website for approximately 120 days a year. Just to show that it is currently on Airbnb, let's have a look on the website here. Here we are, on the World Wide Web. Now, short-time visitor accommodation can be defined as accommodation of less than 90 days duration provided for paying occupants. Now, we have two things to consider here. So that's basically the Airbnb website. And let's have a look at something else. So this is a close-up of the particular advert here for a lovely Victorian home for £170 a night, 5-star reviews everywhere. Now we have two things to consider. Is this a change of use? Has a change in the character of use occurred at the premises and therefore a change of use? And if so, if we decide that there is a change of use, is the harm caused sufficient to take enforcement action? So let's have a look further on. Everyone wants to look at photos and inside properties. There we are. So it looks typically like a normal dwelling house. There's the lounge, there's a kitchen, there's 3 bedrooms that houses up to 5 persons. Now, case law is a rather grey area on this matter. It's ever developing. Now, case law concerning changes of use of short-term dwelling houses states that every case should be judged on its merits on a matter of fact and degree basis. Now, officers here at this council have come up with a working definition of a change of use occurring when let out more than 10 times in any 1 year and for a total period of over 6 months. In this case, we feel that a change of use has occurred when applying those tests. So the second question is there a harm caused as a result of this change of use? Now, officers are of the opinion that harm is being caused for a number of reasons. These are set out in the reasons for service of the notice in paragraph 9.5 of your report in front of you. The main particular one is the loss of permanent residential housing. We would say that this is the most important reason. There are other reasons as well, I'll quickly go over. Going back to the road slide, the use of the premises for short-term physical accommodation is likely to give rise to conditions resulting in increased noise and disturbance. Now, this stems from several things, namely the increased frequency of turnovers of arrivals and departures to and from the premises, especially at times at the weekend. Also stemming from late night arrivals and early morning departures, especially at the weekend, and also visitors potentially not being considerate as permanent neighbours may be, particularly when they might turn up in a group late at night, early in the morning, and when they might turn up possibly in a taxi, when they might dwell on the street, and that could possibly make some noise as well, that might cause a loss of amenity to the surrounding residents. And also, just a final point, just briefly spoken to the owner of the premises who stated that he would have preferred a chance to submit an application. However, an enforcement point of view is that we don't have to give persons a chance to submit an application. We don't have to give them the opportunity, and officers are of the opinion that they would refuse this application anyway. The enforcement notice process does give grounds of appeal under ground A, so the owner could actually apply in due course for a planning permission under ground A. So still getting a shot at it. Okay, thank you very much for your time, and I welcome any questions.
Claire Richards, who's the County Councillor for Castle Ward.
Okay, I'm afraid that I have got a flu cold, so if you excuse me if I can't speak very loudly. As I come to speak in support of this, what I thought was a very good planning report as a ward councillor, it seems to me the report clearly indicates as the reasons for the officer recommended enforcement notice directed at remedying the harm caused by the breach in planning control, the change of use and loss of amenity, noise and disturbance. I want to reinforce some of the points made, most especially the loss of immunity and noise disturbance. I'm going to refer to 3.1 of the report, which is on the second page of the report. It says the site was initially referred to the planning enforcement team by local residents. It was the Residents' Association concerned with noise disturbances resulting from increased comings and goings from the property. Late night arrivals of persons to the property and early morning departures were identified as the main reason for noise disturbance. It was later that the comings and goings were as a result of the whole of the premises being available for rent on the Airbnb website on a nightly basis. A log was submitted by complainants with witnessed comings and goings from the premises. The log alleged at least 72 lets over a year. The Residents' Association have been keeping a log for some time, and they've been suffering from this for in the region of 2 years. I found them to be extremely reasonable, and I found them to be, in fact, I hesitate to use the word, quite conservative in their dealings with this and with officers. They've been suffering from noise, comings and goings, middle of the night, late at night, early morning. Some of them found it difficult to get a night's sleep for substantial periods of time. And if we're thinking about it, 72 lets a year. I mean, not only does it break the planning, not only does it breach planning rules, but also it's got an impact on people's quality of life. And if you're woken up late at night, early morning for many nights, then clearly that's going to have a considerable impact on your quality of life. Also, I think 3.15 is useful here for us to refer to, if we can look at 3.15. In addition, it would not be unreasonable to say that persons booking the premises for a few days are more likely to be in high spirits, either as a group of friends or as a family on a weekend break. Such groups may also arrive and depart the premises by use of a taxi, which will stand idle whilst passengers and bags are unloaded. This may give rise to conditions resulting in an increase of noise and disturbance not normally associated with the character and use of an average dwelling house. This has been happening, and this has been happening on a very regular basis, causing disturbance in the area. And I think it would be true to say that in this context, the visitors to this short-term let do not have an investment in the area in this quiet residential street. I'd also like to refer to 9.52 of the report, which I think is also very significant. At 9.52, it talks about the fact that none of the accommodation being retained as permanent residential accommodation. I want to reinforce this. The officer has shown us today the Airbnb site, and obviously I've looked at that myself. I'd like to point to the phrase that it breaches planning because of an unacceptable loss of residential accommodation. I think it is unacceptable in Castle Ward, which is very much indeed, very much in need of family housing. Thank you.
I'm also a councillor for Castle Ward, and I can confirm what Claire Richards has just said, that there has been considerable disquiet expressed by neighbours as to what's been going on at number 17. But I'd like to focus, apart from the general remarks that she's made, on the impact on those living at number 19, next door. It was 2 years ago that they called upon me to come and talk to them and meet with them to hear about their misgivings about what was happening next door to them. It was quite clear then that they were distressed by the amount of disturbance, and they've been putting up with it now for 2 years. And they've seen this thing go on and on and on, and at last we've got to a point where action is envisaged, and I can only hope that the action will be as prompt as possible. If there are any other contributions, I'd like to hear them. Councillor Smart.
Yeah. So, a couple of things. So, thanks for the presentation, Don. I think you might have made a sort of mistake when you said that, unless I misheard, that the cut-off line was less than 90 days. I think you meant more than 90 days, did you? Because you were effectively saying that just 1 day, use a year, would be acceptable. But you were, yeah, you know what I mean? Okay, you think about that while I say the next thing. So, yeah, I mean, I think, you know, what's been said is right, effectively, and if we've got any powers to do anything, we should do it. But I think you have to bear in mind that, you know, in my ward in these edges, I come across residents who have to put up with HMOs next to them, where they have shift workers coming and going in the middle of the night 365 days a year. And that's worse, but we don't know anything about that. So you have to bear in mind the total context, I suppose, of problems of neighbours, whoever they might be. But, I mean, for me, I think, I don't know if this is an actual parameter, but it seems to me that a significant factor is whether people actually live in the house and then rent some space out, or whether the house is completely a commercial asset, which it seems to be in this case. And that's the way that the city, as I spoke earlier about Mill Road, with its restaurants, gets eaten out. And I know you, John, have spoken about the tourist trade and how there are challenges there. And if the city is going to become somewhere where more and more of it, because the market economy is very powerful, gets eaten out and is used by tourist trade, not by residents, where is it going to leave Cambridge? So I'm completely in favour of the officer report on this. Not for those reasons, the latter I suppose, but for the reasons the officer stated. I'll say that as well. Thank you.
John, do you want to come back?
Through you, Chair, thank you very much. Just to clarify Councillor Smart's earlier comments, the reference to 90 days is actually, so any period of letting for one person less than 90 days, officers have decided to be short-term. Anything over 90 days would be deemed to be a long-term let.
Very good. Well, there is the recommendation for enforcement. John, one last thing. Has anything happened in the last few weeks, months, to suggest that the owner of this property has got misgivings about the way in which this case has been handled, and that he's asking for more time for the enforcement action? Is that the case?
There has been a conversation. Apologies, Chair. There has been some conversations with the owner and the representatives recently, when he has said he will comply, or his representative said he might comply, but then that seemed to have changed, and now it's the case of that he actually wanted to apply for planning permission to try and keep it. But the nature of this is enforcement officers and the council don't have to notify persons when we're taking action against them. And it is a kind of a dark art, taking action or proposing, seeking authority to take action without notifying people. However, sometimes this is necessary in order to keep a tactical ground.
What would be the nature of the action?
So the nature of the action is today that we propose this enforcement notice, and basically requesting or saying that the use cease at the premises. And also to remove all advertisements from the premises. The reason I ask for that, it would be a lot easier to determine whether the cease is used or not. Because if there's still adverts, potentially it could still be let out.
And if the committee gives you its support today, when would this enforcement notice be issued to the owner?
Within the next 28 days, Chair. I have a very busy table at the moment, but I would like to ideally get it out by the end of the week.
And once that enforcement notice has been enforced,
yes,
any offence against it results in court action.
Yes, I would, under the scheme delegation company, I will come back here and ask for action for prosecution of the Chair.
Well, I hope that neighbours who've been affected are reassured by those reassurances that that we have attempted to secure today. That is the position, and I think it's one that I hope you all receive. The recommendation is for enforcement in this particular case. If you approve of that action in the ways that have been described by John Shuttlewood, please indicate. You have our 100% support. And thank you to the neighbours who have come along today and who are understandably concerned by this. I hope so you feel reassured, and Madam, you too.
So council has decided that the person who is renting out their property on Airbnb on Richmond Road needs planning permission for that use. And their report suggested that planning permission would be required for any renting of a property for a period of less than 90 days. Now that is a significant decision there by council. Now I know today's decision was just on an individual case, it wasn't technically a policy decision, but if they're going to apply that standard elsewhere around the city, then the availability of short-term accommodation for people whose perhaps families want to come and visit them, for sort of major life events, perhaps for a wedding or a birth of a child, or people who want to come and work in Cambridge for short periods of time, as many people do, then the availability of accommodation for those purposes may well be reduced. I think this is a massively significant decision here for the City of Cambridge, and I think it's also potentially a decision with significant national impacts. For example, in Cornwall, where councillors look to see if they can regulate holiday letting. If councillors in Cornwall applied the same rules as we saw applied here in Cambridge, that planning permission is required for any rental of less than 90 days, then that would give councillors much more powers to restrict what people can do with their properties. So it would be interesting to see what happens next, whether this is a one-off, or whether or not this is the start of quite a big change in the way that councillors regulate how properties can be used, both in Cambridge and around the country. Now, my own view is that some of the most extreme cases of nuisance and problems should have been dealt with via police and council enforcement, but I understand that you can't rely on police and council enforcement for things that keep happening. So in the case of Richmond Road, there probably was a need to do something else, but if persistent nuisance is being caused by the way a landlord is using their property, then I would have thought that you could go to court and seek an injunction against that nuisance being caused. I think that would have been perhaps more appropriate than trying to use planning law in this case.